Hello friends, Namaskar. I am Anil Kumar Srivastav and I shall today discuss about some articles and objective type questions on polity and our Indian Constitution. Let us start. The first question is: no confidence motion is presented under which article of the Indian Constitution? The options are Article 74, Article 75(1), Article 75(2), Article 75(3). Once again, I am repeating the question. No confidence motion is presented under which article of the Indian Constitution? The options are Article 74, Article 75(1), Article 75(2), and Article 75(3). The answer is Article 75(3) of the Indian Constitution. The no confidence motion is presented. My next question is: the no confidence motion is presented in which of the houses? The options are Lok Sabha or Rajya Sabha or higher house or lower house. The option is Lok Sabha or Rajya Sabha, and that is also lower house or upper house. The answer is the no confidence motion is always presented in the Lok Sabha or the lower house. My next question is: what is the requirement of the for presenting the no confidence motion against the government? The options are: 1 MP can present the no confidence motion, and the 10 MPs can present the no confidence motion, and 1 MP supported by 40 MP can move the no confidence motion against the government, and last one is one MP and supported by 50 MPs can present the no confidence motion. The answer is the one MP supported by 50 MPs of the Lok Sabha can present the no confidence motion. My next question is: by which amendment the Anglo-Indian community has lost the reservation for the Anglo-Indian community has been terminated or has been removed? The options are 104th Amendment of the Constitution, 102 of the Constitution, 103 Amendment of the Constitution, 101 of the Amendment of the Indian Constitution. You have to tell the question, of course, is by which amendment the Anglo-Indian reservation has been removed. The options are the Amendment 104, Amendment 102, Amendment 103, and Amendment 101. The answer is 104 of the Amendment of the Indian Constitution has removed the reservation of the Anglo-Indian community. So you can find that my next question is: what is the confidence motion? Confidence motion is presented by whom? The options are by the government, and the second option is by the opposition, and third option is none of these. The answer is confidence motion is always presented by the government. My next question is: how many confidence motions have so far been presented in the Lok Sabha, and excluding those which has not put to the vote? The options are the number of the confidence motions so far moved in the Lok Sabha, excluding that one which has not been voted or put to vote. The options are 22, 11, 10 and 13. Answer is 10. There have been 11 confidence motions so far been moved in the Lok Sabha by the government, and one of them has not put to vote, so excluding that one, the number reduces to 10. My next question is, by which confidence motions the government have fallen, out of the following, which one is true? In the 1990, the confidence motion has been presented by the then Prime Minister of India, by B.P. Singh, and the second one was presented by the PM Deo Gowda in 1997, and the third was presented by Atal Bihari Vajpayee in 1999, and none of these and all of these. The answer is all of these motions have succeeded, confidence motions have failed, and that is why the government has to go and has gone. My next question is under which article of the section there is a provision that the High Court and the Supreme Court, the language used in the High Court and Supreme Court will be English, unless the Parliament provides otherwise. The options are 347, 348 1A, 348 1B, 388, 351. The answer is 348 1. Under 348 1 there is a provision that in the High Court and Supreme Court the language will be English, unless the Parliament provides otherwise. My next question is, in which of the article of the Indian Constitution there is a provision that the legislature of any state or the Parliament must use English in their acts? The options are 347, 348 1A, 348 1B and 348 1C. The answer is 348 1B. My next question is, by which constitutional amendment there is provision has been made that in which section there is a provision that the primary education should be given in their mother language? The options are 348A, 349, 358B, 350A. Answer is 350A. There is a provision that the primary education should be given in the mother language. And in which article it has been given that President can change it, that the primary education should not be given in the mother tongue? Which section allows this? 348A, 349, 350B and 350A. The answer is 350A. My next question is, in which article there is a provision for making and appointing a special officer for the linguistic minorities? The options are 348, 350, 350A, 350B. The answer is 350B. My next question is, it is the duty of the center that it shall promote the Hindi language. In which section it has been given? 348, 350, 350A, 350B, 351. It is given in 351 that the center shall take all steps to spread the education of Hindi, to promote the Hindi. By which amendment the section 333, the 338B has been incorporated in the Indian Constitution? The options are 102 Amendment Act, 101 Amendment Act, 104 Amendment Act and 103 Amendment Act. The answer is 102 Amendment Act. It has been provided. My next question is, by which constitutional amendment there has been made a SC Commission? 338. The options are by 102 Commission, 102 Amendment, by 103 Amendment, by 104 Amendment, by 89th Amendment Act. So it has been made by 89th Amendment Act. Under which article of the Indian Constitution? 338B, that is the ST Commission has been made. The options are 102, 103, 104 and 89th Amendment Act. The answer is, it has been done by 89th Amendment Act. My next question is, under the SC Commission or ST Commission or the Backward Commission, how many persons are there in the commission? The options are 3, 5, 4 and 2. The answer is, there are 5 persons in every commission, but there are 3 are members and 1 is the chairperson or chairman and second one the vice chairman. My next question is related with the details of this section, and now these will not be in the form of the objective type questions. These will only tell you what has been said in the relevant article. Article 53 says that the executive power shall rest in the President. Article 54 talks about the election of the President, that the election of the President or the electoral college of the President will be made up by the elected members of the Parliament and elected members of the legislative assemblies of the states. This will form the electoral college for the President. My next question is, what is the provision in of election of the President? The President is elected by the proportional representation and single transferable vote. Article 56 is about the tenure of the President. The tenure of the President is 5 years from the date when he was taken charge. And my next section 57 is that the President, a person who has remained President, can again be a candidate for the President. And my next options is, what is the qualification of the President? That the qualification of the President should be that he should be eligible for being chosen as a member of the Lok Sabha, and he should be the Indian national, and thirdly he should have completed the age of 35. And in the 59, some conditions have been made for the services of the President, that the President should not hold any office of profit except this one, and the President's allowances and salaries cannot be reduced in his term, and he should not be a member of the Lok Sabha or Rajya Sabha or the state assemblies. And the section 60 talks about the oath. The CJI will get him the oath will the CJI will be the oath of the office will be shown in after the by the CJI. CJI will read the oath and he will take the oath. And if the CJI is not available, then the other senior judge of the Supreme Court will read the oath and the President will take the oath. And the section 61, that is the impeachment, that is the most important article, that how the President can be removed from his office. That is, there is only one ground by which the President can be removed. The one ground is that he is violating the Constitution. Only on that ground President can be removed. But before removing, there is a procedural matter. The objections should be made in one house and President should be informed about it 14 days before, and then the impeachment will come into one house and it will be passed by 2/3 of the total membership of that house, and thereafter the other house will also takes up this impeachment, and in other house, if it is passed by 2/3 majority of the total membership of the house, then the President will be removed from his office. In the 63rd, there is a provision that there shall be a Vice President, and there is a 64. In 64 talks about the President will be the ex officio chairman of the Rajya Sabha, and in 65 it has been provided that when there is a vacancy in the President's seat, the Vice President will discharge the duties and functions of the President. And in section 66 there is a provision that the manner of the election of the President has been given, that the both houses of the Lok Sabha, that is Lok Sabha and Rajya Sabha, both will elect to the President. And the tenure of the President in section 67 is 5 years. And in 69 that there is a provision of oath to the Vice President. In the section 70 it has also been provided, during some contingencies the Vice President will again discharge the functions of the President also. In 72 there is a power of pardon is given in this, that there can be a remission, there can be the conviction can be, the life imprisonment can be converted into, the death sentence can be converted into life imprisonment, or the greater imprisonment can be converted to the lesser imprisonment, and these can be done by the President. And in the 73 we find that the power of the executive, that the President will be as long as the power of the Parliament. Now we come to the section 245(1). Here we are going to talk about the distribution of the powers. That is very much important. In 245(1), it has been provided that the state can make, that the center can make a law for whole of the country or some part of the country, and similarly the legislature can make a law either for the whole of the state or for any part of the state. And it has been provided in 245(1) that because there is a business, the Lok Sabha and Rajya Sabha are busy, so they can delegate their power to certain authorities, and that the authority will discharge that duty. But there will be two types of control over these delegated authorities. One will be from the court side, that is called the judicial control, other will be parliament control, and under this this authority, delegated authority, will function. And besides, we can also understand in which conditions the India has adopted these the 245 one or the 7th schedule, that is the state union list, central list, and union list, state list, and the concurrent list. The makers of the Constitution have studied the American Constitution, the Australian Constitution, the Canadian Constitution. The American Constitution is made in the conditions that its states have surrendered some powers regarding the national level, that is the foreign affairs, finance, and the defense, etc., to the center. So in America we find there is only one set of list for the union powers, and the other powers will go to the states. And Australia has also incorporated in the same type of the federation, but because of the loose federation, America has to face problem of disintegration, and that is why the Canadian has understood this, and they have made the constitution in which the center is stronger, and they have made the central list and they have made the provincial list also, but the third list is not listed there, but it has been said in the constitution that the remaining things which are not coming in the state list or the union list will be exercised by the center. So here we find, and if in 240 and 245 second it has been also said that if center makes some law for the beyond the territory of India, no state can challenge this, because in certain conditions that law can be used in other areas when our fugitives or when our criminals go to the other state, then under that law we can claim those prisoners or those offenders, and it is up to those states which accept our rule or not. It will be seen later on. So my next question is 246. In 246 it has been provided that the center has a full and exclusive power over the state list, and it can make any law for any part of India or for whole of India in the articles or in the entries of the union list. And in the second part it has been said that the center can make a law for the in the field of concurrent list also, and state can also make a law for this and for the on the concurrent list. And last one is that the remaining list which has not been given will be those list or those powers will be used by the center. So this is the article 2446, and into 246A under the GST it has been provided that the central will impose the taxes inside the state into 246(1) GST, which has been which has come into force after the 101 amendment of the Indian Constitution. And in 246A(2) it has been provided that in the interstate transport the GST will be imposed by the center. We now come to the 247. 247 is an article through which for the benefit and for the interpretation of the article, Parliament can make a tribunal, so that it can interpret the law and decide the things. And under 248 the residuary powers has been given. So here we find that the in the residuary powers, the something at some time it happens that the center is encroaching in the powers of the state, and at the other time we see that the state is encroaching in the central list, the entry of the central list in the form of the disguised manner, or in the form of the disguised form. So here the Supreme Court interprets every entry to the broadest sense, and then it harmonizes that in which this entry will come, whether it will come under the jurisdiction of the state or the center. And similarly, when the legislation in case of disguised amendment is made, disguised encroachment is made, then it is called the culpable legislation, and then the culpable legislation and the pith and substance theory is also adopted. What is the true spirit of the makers of the Constitution, that is here applied, and according to the interpretation the power goes to that either center to the or the state. In the 249 it has been provided if certain provision or certain matter in the 7th list of the state list, two states or more states are agreed that the regulation or act should be made by the center, and that act will be bound to those states, then center so it is, of course, we are discussing about the 249. 249 is something that if the state finds that something is very necessary, and the Rajya Sabha thinks in the national interest that the 2/3 members vote in the state list matter, that the law should be made by the center, then if that resolution is passed by the Rajya Sabha by 2/3 majority, that certain topic of the state list should be made by the central government, then the Parliament will make the provision. And in Article 250 we find that there is a provision that when the 352, that is the external aggression or the rebellion is there, and 352 is enforced, emergency provisions are enforced, then the Article 249 all the powers are related to the state list goes in favor of the center. The center can make even law even on the state matters. In 251 it has been provided that in 249 and 250 what has been given and what is the law has been made by the center, and those law and similar laws have been made by the states, and if these two laws are in conflict, then the central law will hold and central law will prevail over the state laws. And in 252 we find that the two or more states are agree they want some two and more states are made a resolution from two or more states that center should make law on the state list, then the center will make the law on this on the subject of this list, and that law will be bound by the states which have passed the resolution, which has made an appeal to pass the law by the center. And in 253, the government signs different kind of international treaties under international law, and the laws to implement it in India can be made, and no state can deny that this should not be done. And so for enforcing the international law, if any agreement is signed by the Union of India, then India can make any law which will affect some or more of the states of India, and no state can deny it. So we are coming to the end of in the 254. If there is a law made by the center and law is made by the state on the concurrent list, and there is a conflict in those laws, then the state law will give way to the central law, that the central law will prevail over the state laws. And lastly, in 255 it has been provided that if some bill is passed by the Lok Sabha or Rajya Sabha or the state assemblies, and where there was a need of the approval of the governor or the president, as the case may be, and in that case it will be taken as a procedural error and law will be valid. That's all for today. Thank you.